Hi, I want to welcome all of you to NYU Law School and for joining the Center on Civil Justice's Fall Conference, recent legislative responses to litigation finance, in case you're not sure if you're in the right room. My name is Janet Sable, and I am the Center for Civil Justice's Director on Access to Justice initiatives. I am standing in for Sheila Birnbaum, who is the interim director of the Center on Civil Justice, but she was not able to join today, but sends her wishes for a productive day. We are so excited to be hosting this hybrid event. We're thrilled that so many of you were able to make it to NYU and New York and the beautiful weather. And we know that there are quite a lot of people on the Zoom. At some point, you'll probably hear the total number, but there's a very large Zoom turnout as well. So just a testament to how critical this issue is and how important it is for folks to be thinking about it. We're excited also. This is our third conference on third-party litigation funding, following last year's Emerging Trends in Third-Party Funding and a conference a few years earlier on dispute financing, COVID-19, and other developments that all followed from our original event in 2019 of the future of dispute financing, pricing, profits, and policy. The events tie into our Center on Civil Justice's Dispute Finance Library, a searchable document database containing many of the most significant statutes, cases, articles, and more on the subject of third-party financing. The website is free to use and is available at disputefinancing.library.org, and we're going to be linking it as well to our Center on Civil Justice website. So we are incredibly grateful to our Dispute Financing Library Advisory Board, both for their help with the website, but also for their assistance at this event. There are many of the board members here, too many to mention, but you will be meeting them throughout the day. And we are just thrilled for the support that they have lent the center and this project. And most importantly, I want to thank Eric Schuler, who, in addition to being a member of the Center on Civil Justice's Dispute Financing Library Advisory Board, is president of the Alliance for Responsible Consumer Funding. This conference came from him, and it never would have happened without his hard work and support and outreach to so many of you. Special thanks also go to David Siffert, the Director of Research and Projects at the Center on Civil Justice, for identifying the great speakers and really filling in this whole event to make it as productive as I'm sure it will be. Also want to thank Mindy Darwish, who's sitting outside and who made sure that everything works today for all of you, from food to name tags to CLE credits. I also want to thank the National Law Review, the Litigation Finance Insider, and Legal Funding Journal for their help in promoting this event and helping us to get such a strong turnout. So one quick piece of housekeeping: if you want to receive CLE credit, as we have mentioned, it's only available to those of you in this room. You must sign in and sign out if you want to receive credit, so please remember to do that. And Mindy will be at the desk if you have any questions about that. Lunch is for you to socialize, and it will be provided later on. And I would now, again, like to welcome you and to turn the microphone over to Eric Schuler to give opening remarks and to introduce the first panel. Thank you so much.
Good morning. My name is Eric Schuler. I'm the president for Alliance for Responsible Consumer Legal Funding. We're the largest trade association that represents companies that offer the consumer legal funding product. And I'd also like to thank the center and my other advisory board members for helping put this together. the purpose of this event, let me just back up a little bit. When there has been other events dealing with litigation financing, a lot of times I've seen them being siloed. It's on the people who don't like the industry and the people that like the industry. And never the twain shall meet. Well, we tried to put an end to that here. So what we wanted to do when we were organizing this was to have a balanced panel, a little bit longer panel discussions, but where everybody can talk to each other and not at each other. So I encourage our panelists to talk to each other, not at each other, socialize over lunch, exchange business cards, because I think what you'll find out is there is a common ground no matter what the issue is. Find that common ground. Find that one thing that you can start with and build from there. This is something that's not going to go away, either on the consumer side, or the commercial side, or the international side. So we all need to kind of live and be able to work together. So that's what we're trying to do. I also encourage the audience to ask questions, especially our audience online. We do have somebody monitoring that. And we're all going to leave time for questions at the end. Ask questions. As my third grade teacher used to say, no question's a dumb question. Ask your questions. Get to know, figure it out what it is. And with that, I'd like to invite our first panel up on the disclosure of commercial litigation financing agreements, and let's get this party started. Thanks.
Mayor, over here.
No, I asked ChatGPT.
Okay. Hi, everybody. My name's Emily Siegel. I'm a senior reporter with Bloomberg Law. I cover litigation finance. And for our first panel, we're going to be talking about U.S. Federal and state legislation regarding disclosure of litigation finance, which has been a pretty big issue in the industry. A lot of people have differing thoughts on it, and a lot of people on this panel have differing thoughts on how disclosure should be done, whether it should be done at all. So I'm really excited to get started. I'm just going to introduce everybody. Next to me is Mark Behrens. He is a co-chair of Public Policy Practice Group at Shook, Hardy, and Bacon, and he is representing the defense bar and is pro-disclosure. And next we have Daiwei Chin Feeman, who is a managing partner at Parabellum Capital and is also speaks a lot about public policy and litigation finance. And we have Andrew Cohen, who works at Burford Capital. He is responsible for assessing and underwriting legal risk at Burford, and he also monitors policy and regulatory issues. And finally, we have Maya Steinitz, a professor of law at Boston University, and she is writing a book called Litigation Finance, Law Firm Ownership, and the Future of the Legal Profession. So this is all our panelists, and I just want to get started with kind of a general question, starting with Mark. So why are you pro-disclosure? Why do you think it's necessary to have disclosure in the litigation finance space?
Thank you very much, Emily. It's an honor to be here. I want to thank Eric Schuler for inviting me to be the foil to these guys here. You know, when I've talked about this, I always use a quote from Maya because it's a really terrific one, that litigation funding is fundamentally transforming our civil justice system. The funding is now going to decide which cases get brought, how they're handled, when they settle, and for how much. But this is quietly being done outside of the public view. And on the business perspective, I'm not here today for any particular group, but I've testified for the U.S. Chamber and states, and I work on a TPLF subcommittee for Lawyers for Civil Justice. So obviously my perspective is going to be civil defense side. Our firm represents mass tort defendants, and so that's my perspective. I think that, in a nutshell, TPLF can do some good things that help provide some access to justice. And so the reform efforts have not been aimed at banning this practice, but there are some downsides to it. From the perspective of mass tort defendants in particular, there's a feeling that it's fueling unsupported litigation, speculative litigation, that it makes cases harder to settle and more expensive to settle, and that sometimes when parties are ready to reach a resolution, that they may not be able to do that because of the presence of the funder, or a concern that they reach a resolution and then the deal blows up because somebody who has not been party at the table reaching the settlement has suddenly put a veto on it. So those are the main concerns, and then we can go in a little bit about what the effort for disclosure is focused on.
And Daiwai, can you talk a little bit about why litigation funders are less keen on disclosure?
I think we love disclosure, and we're looking forward to getting past all of this. It's incredibly time-consuming, Mark, what you're doing to us here. And we actually do have a job. We need to get back to controlling litigation, so please stop taking away our time. I think, and I keep saying this line, we don't have anything to hide, we have something to protect. And I'm really at a loss more and more because I can't say that enough times. We can't write enough articles that say, hey, Mark, your subcommittee's putting out these proposals that we get you may have some arguably legitimate interest here. No, we don't want a conflicted judge either. I don't like funding a case where the judge traded in the stock of the defendant, which just happened to me, and then he J-mailed us. That was great. I don't want that either. I don't want this noise, but what I can't have is prejudice coming from disclosure. So I'm looking forward to a place where your side kind of wakes up and says, well, we're saying this, they're saying that. If we're going to get something done, it has to be in the middle here. By the way, the middle, I think, would be good for you guys. It's better than what the courts are giving you. The courts say it's irrelevant and or protected from disclosure. You're not getting anything. Broad, sweeping, open-ended, Trojan horse-type proposals, that's what we're against, and that's what we fear. And the proof's in the pudding. It's not just, oh yeah, we're gently seeking if the judge has a conflict. It's no, here's a subpoena to funders, potential funders. Here's document requests, interrogatories. We're going to ask about it at depositions. We're going to go nuts and try and make this a weaponized pain point. And it would be very ironic for litigation funding, which does a lot of things, but at bottom, we're helping even the playing field and provide access to justice. It would be pretty twisted if, in doing so, we created a new defense that made these claims now vulnerable and hurt them. So I think that kind of sums up my position.
And Maya, I know that you've taken a bit of a nuanced view on disclosure. Can you describe how, as somebody who's been studying the industry for a long time, how you view the best approach to this?
Yes, so I've written that I think there's too much variability in litigation finance for a one-size-fits-all approach. In terms of whether funding should be disclosed, if so, how much, to whom, and at what point. And so I propose to leave it to judges to do a balancing test based on a whole set of factors and considerations that I proposed. So that's my view as a theorist. But since we now have some proposals before Congress and elsewhere, I do want to say something about those proposals. On the one hand, I think they're overly broad, but I question whether this battle is as important as conferences on the top. It seems to be the #1 policy discussion in litigation funding, and I find myself questioning why that is. I think that when we look back in 10 years, this will probably be seen as a non-issue. I think we're moving actually slowly towards some disclosure. I think that's the trend, even though, if I had to guess out of the blue on any given case, are you going to get disclosure? It's probably no, but I think that the trend is towards disclosure, but it's happening through this patchwork. And so I want to ask that we examine why, what were concerns of funders and plaintiffs' lawyers 10, 15 years ago? Right, and they had to do with the knowledge that there is funding here is tactical and strategic. I think that point is moot at this point. Sophisticated defense lawyers all assume that there's at least, there may be, right, and they conduct themselves appropriately. There was a concern that these contracts are proprietary financial contracts, that they're IP of the funders. And I actually think that in some cases that's maybe still the strongest argument, but I think that the practice is moving towards standardization. That was at an age where most lawyers had no idea how to negotiate these, and I think remember?
Yes.
So, chuckle, right? Thank you for the, I didn't pay Andrew in advance to chuckle at this point, right? We kind of all know how to do these contracts at this point, so the IP issue is, I think, moot. And then there's the issue that all of the satellite litigation is expensive for everyone. But I actually think that the lack of clarity and the patchwork reality that we live in, where it's literally judge by judge, it's not even state by state, that's increasing the cost of litigation around the disclosure issue for everybody. So I actually think that we're probably trending towards more disclosure. It may actually benefit everybody to just say, let's have some disclosure and have clarity as to when and how much we disclose, and be done with a lot of the just litigation around it.
So I think we should start talking about the federal legislation. There have been recently, Congressman Darrell Issa introduced legislation that would require disclosure of third-party funding as well as disclosure of litigation finance agreements. This is the 4th attempt at federal legislation. The first 3 have failed. So I'd like to start off with Andrew. What do you think about this recent attempt? Do you think it should be sort of lessened, or do you think this is a more moderate approach than some of the past ones?
So the current bill that Representative Issa introduced, H.R. 9922, is, I think, as broad a disclosure bill as has been introduced, certainly at the federal level and anywhere in the federal courts that I know. Maybe there's some, possibly some broader state legislation that might even go further, but in terms of disclosing, not only the fact of finance and the identity in the documents, but also more information about the funder. I think that the bill is, as you say, broad, and doesn't represent the need that we're identifying for disclosure, right? We're talking about, there's some need for disclosure. Disclosure of what? To whom? For what purpose? We want to, I think we want a least restrictive means approach when we're talking about disclosures that are going to affect rights of litigants. And so we don't want to just, open up the barn and see what's inside. We actually want to be strategic about it so we're not prejudicing litigants on either side. So, I appreciate attention to our industry. Like, it's of course nice to be noticed. I don't think that this is the right approach. I think this is an approach that will lead to increased costs for litigants because, as we say, there's satellite litigation on issues of, on additional discovery requests, on, what's protected, what's not. Why should we be required to produce this information? I don't think this bill is going to help that. I think it's actually just going to make it more common for there to be litigation about these issues when there's really no purpose or benefit. I think that there's an approach that might be working better, which is Federal Rules, Civil Rules Committee just created a subcommittee after many requests from the chamber to do so. And that will require study. Maybe there's folks listening right now that are part of that attempt. They're going to come up with a proposal that is, at least in theory, a balanced approach that is not going to shift the needle of benefits to one side or the other, but merely find the disclosure that is necessary for litigation in the least prejudicial way possible.
And Mark, can you talk about why you might think it's necessary to disclose the litigation finance agreement as opposed to just disclosing the presence of litigation finance?
Sure, and because that has been something, well, we can just alert the other side that there's financing in a case. And as Maya was saying, probably in the mass tort case, we can assume that today, that it's so prevalent. If you have a Camp Lejeune case with the government, a Roundup case, any of the ads that you see on TV, they were probably being funded by outside funding. So why would we want the agreement? Because the agreement will tell us, maybe, how much control, if any, that the funder exercises in the case. That really is what the agreement will tell you, and that's why it's critical to see that, to see how much funding control does the funder have, and the control could be express. You know, we have veto authority over this case. Before any settlement's made, you've got to run it by us. Or it could even be a little bit more indirect, where control would be, we're going to provide funding in different tranches. We're going to give you funding, you know, now, and then 9 months from now, we're going to kind of see where we are, and then after that, we're going to give you a third round of funding, because, you know, what's the golden rule? The person with the gold rules. And so there's a feeling on the defense side that in a situation like that, the funder can wield very substantial control, indirectly, by just saying, these are the experts we suggest you use, this is the way we suggest you go about the litigation, and we all know if you don't do it that way, you're not going to get the next round of funding. So even though the agreement may not say, we've got veto on this, the short answer is, if you don't play ball the way that the funder may be suggesting to you, you don't get the next round of funding. And so that pressure is there, even if it's not expressed, that you're going to have to do what they suggest or you're not going to get paid. And so those are the concerns that on the defense side.
Can we
about
just
control.
play that out really quickly?
Yeah,
So
yeah.
let's say I'm a funder and I say, do this or else. And then they don't do it. Then I just what, like lose my investment? Would that be prudent? Would I be fulfilling my duty to my investors if I did that?
Well, maybe at some point you decide not to keep throwing good money after bad. So maybe.
So the case is bad because
Well,
they
the
don't.
case may not go bad, but, you know, I do think that this does go to how much you all want to control the case. And there's a lot of suspicion on the defense side about, you know, we hear that there's no control over this. You know, the one example and is the Cisco case that people may be familiar with. And, you know, I know there's more detail than has come out, so I don't want to go into this for 20 minutes, but, you know, in a nutshell, at a very high level, what's been reported is that at some point, Cisco, which is a large food supplier, was trying to negotiate settlements in antitrust claims brought against its protein suppliers, you know, suing the companies that supply it with chicken, supply it with pork, and so forth. And Cisco had an interest in resolving the litigation against their suppliers. They don't want to bankrupt them. They have to work with these people. They were working out a resolution, and as it's been reported, that Burford blocked that because there wasn't enough money for what the funders wanted. Now, I know that that's a very superficial.
Yeah, are you
and
sure you want to
guys
use
can
this
dis-
example? I mean, this
Well,
one's
yeah, because
fraught
that's
with.
been reported, and it goes against what the CEO said on 60 Minutes, which is, we do not control the litigation, we are passive investors.
Correct.
And that's why when we see reports like this, it raises suspicion on the defense side that where there's smoke, there's fire. We've been told that there's no control. The CEO said there's no control, and yet there have been reports, I think even in your publication, that there was some exercise of control. And so we, you know, that raises suspicions on the defense side about how much control, and is it in every one of these cases?
Okay, so I think that's helpful. The first thing you said, I felt a little glimmer of hope because the notion of control, well, all of our contracts say we don't control very explicitly. We're advised by ethicists, many of whom are in the room, on these things. There's no doubt at all. But it kind of, so there's many solutions. We could have representation to the court. We could have a pollster style like disclosure regime. We could have parties tell the court there is no control like in 711, and to the extent there could be anything in the contrary, this controls, and we submit to the jurisdiction and agree for that. That's all possible. But this begs the question of what your definition of control is, because on the one hand, there's kind of the 711 definition of control, which I think is pretty far to the, you know, the obvious side, and then there's kind of what you're saying, which is more the design line, you know, North Carolina bankruptcy decision, which says, well, the power of the purse is control, and anything could be control. And if we're in that world, then I think you really are seeking the agreement, and I think there's no way for a compromise if that's going to be your definition. If you want to be more kind of by the book and say, well, do they actually have control rights? Or, because basically what you're saying is we craft an economic framework that has various incentives, just like there's economic incentives around every business transaction, every representation by any counsel, anything. Just strictly by virtue of designing those incentives, we're going to create control. I think that is extremely wishy-washy, and I think Maya could write probably a whole nother book on control.
I'd also like to point out, we're talking about apples and oranges here. The Cisco situation, which I would dispute your description of facts, but that was a client-side funding deal, right? It was a monetization of litigation. It wasn't even litigation funding, it was just a legal finance transaction, corporate finance. What you're talking about in the mass tort, Campbell's Union world, is law firm side funding. And when we're doing deals with law firms, the lawyers are still subject to their ethical obligations, right? So if any funder thinks that they're going to take control over what the lawyer's doing, and we're going to step in front of the lawyer's ethical obligations, we've got a totally separate issue here, which is that we no longer trust lawyers to perform their obligations ethically. And I don't know why we suddenly assume that in the funding context, especially when you already have lawyers who've been taking funding of various sorts for years in other ways. Why is specialty finance from Daiwei and me different from a bank line where a lawyer's putting up their house as collateral? Why do we not trust lawyers in this context to give independent professional judgment?
Can I ask a question?
Yeah.
Are the clients always informed when there's funding? Because there was one case that I saw reported in Philadelphia where a plaintiff's lawyer received funding, about $81,000, and the case ultimately settled. It was a workplace injury case, and the case settled, I think, for about little over $400,000. And the client is suing because when the client got the bill at the end, essentially, of how much you're going to get, there was $140,000 taken out of his recovery to pay for funding that he said, I never knew about. Nobody told me that a quarter of my money was going to pay for a funder that was in a case without my knowledge. And I probably wouldn't, this is what he said. And so maybe if you could comment on that, because I think that's a problem there from the consumer standpoint, is how much is the client being told of this, and especially when the cost may be passed on to him or her.
So just in terms of maybe ground rules, this is the commercial disclosure panel. You've given, I think, 3 answers now. The first two involve mass tort, that one involves personal injury. I think there's different considerations in all of them, and what you're flagging here is probably Eric Schiller's panel could speak about consumer protection issues.
The money went to the lawyer,
in a personal injury
not to the
case.
person.
We're
It
here
wasn't a
talking
loan-
about-
It wasn't a loan to a consumer. It was a loan to the law firm to support the litigation. And when it was settled, the cost to that paying for that funding was passed on to the client without the client's knowledge. He's suing.
I
That's
wrote-
all.
It sounds like it was
reported.
independently wrongful, like a lot of the
That has nothing to do
anecdotes.
with funding, that's just
That's
Right.
what was reported.
It's
All I'm
like-
saying is he's got a lawsuit because he said, my lawyer charged me $137,000 for something I
That's
never
an
knew
independent
about.
ethical violation, right? That has nothing to do with the fact that funding was involved, if in fact that's the situation you're describing. It's just lawyers doing, financial practices they're not allowed to do.
But
Well,
the question
do the
you're
clients
asking,
know about this?
well,
Are the clients told when there's funding
So,
in their cases?
To answer your question,
It's a 1.5 question, it should be in the retainer.
but
That's a simple ethical.
I mean, it's a simple yes or no. Are the clients told when there is funding in their cases?
I think the answer to that might be maybe yes in some cases, maybe no in some cases. And I think that that's going to vary by jurisdiction, what is required under the local rule 1.5.
or if you have a large facility with a bank, a tort firm, if we're allowed to talk about torts here, and they refinance it to save a couple hundred basis points, did they tell the clients about the bank? And now is there a recourse, non-recourse distinction that's material to you?
I think in this question, in this context, the issue goes to the lawyer's ethical duty to maintain independent judgment. And the client should know if the lawyer is in a position where that could be compromised, or at least raise the perception of potential for compromise of that obligation.
But I think the point is that we don't require lawyers to disclose to their clients that they have a personal line with, Huntington Bank. that is near its limit. And if I don't get paid on your case in the next 6 months, I might lose my house. That is not a disclosure that lawyers make to their clients in normal course. But those situations exist. So the question is, why is litigation funding, qua Daiwei and me, different from the current rules of legal ethics as they apply? You can make an argument that lawyers should be required to turn over their entire financial records to every client who asks for them. I don't think that's a good idea, but you can make that argument. I just don't think you should make it, well, if it's specialty litigation funding, then it's one thing. If it's any other kind of conventional funding, it should be another thing.
I will say I did write that article that you're referring to, and I do think I spoke with Eric about it. From Eric Schuller, and he said that was sort of a rare situation where there was a conflation between commercial and consumer and plaintiff lending, and I that was the only time I've written about it.
Again, we see reports of these, and then we're always, told, oh, that was an aberration, and we don't know. There's so much secrecy in how this goes on that, maybe at some point you guys do jump on the disclosure bandwagon because it would help clarify some of these issues that come up.
So in terms of disclosure, I mean, Maya, maybe you can opine on this. Do you think in-camera review, as opposed to public disclosure, could satisfy both sides of this argument?
Well, I think that's also, I think that any bright line rule, this is the one thing we should do in all cases, is too broad. And one thing we've seen here is a discussion about whether commercial litigation funding and mass tort funding are the same and should be treated the same, or they're different. They're clearly different. They raise different issues. In mass torts, we've always been concerned about lawyers, despite having ethical obligations, not adhering to their ethical obligations, and that's why Rule 23, when I teach Rule 23, that's the class action governing rule. I have my students do an exercise, and I tell them, try to trace, based on the language of the rules, all the conflicts of interest. And see how they sort of, this rule, it's a very long rule, it's very boring, and I try to make it interesting, and I tell them that I can count more than 30, so I'm challenging you. So what do we do in the aggregate litigation context, where we realize that legal ethics and the lawyer's responsibilities is not enough? The incentives and other structural issues are so overwhelming that the court just needs to step in, and the rules actually flag to the judge and empower the judge and the profession and the lawyers. Like, this is a context where courts need to supervise the conflicts of interest because they are inherent, they are structural, and so I think third-party funding of aggregate cases, whether they're aggregated in the sense that they're mass torts or they're aggregated economically through the device of the portfolio, should be treated differently than a transaction in which it's a one-on-one kind of situation. Also, I do think that a very empowered party that's truly using litigation funding as a form of corporate finance is different than other players, entities, or situations in which there's an unlevel playing field, or in which the funding is truly sort of make or break. And that doesn't have to do necessarily with the sophistication. It's not just of the plaintiff or just the consumer cases, but if you have an entrepreneur, they have an IP case, their patent may be worth many billions of dollars, they're an engineer, so we look at them like, you're a sophisticated person. They may not, they probably don't understand the financing, have no bargaining power vis-a-vis the funders, even if they willingly contracted into it and they were represented and so forth. So this is a situation where I think a judge should use just common sense and say, I understand that there's indirect economic control in these kinds of situations. The funders should not exercise it, even though it's baked into this relationship, but they're profit-seeking, as they should be. That's their one and only goal. And so, and I know that lawyers, because Emily has been reporting on it and others, that lawyers don't always adhere to their ethical obligations, and I'm not naive to think that that's the end of it. So I'm going to step in here and I'm going to ask some common sense questions. And so I think one of the things that we're seeing is that judges are increasingly starting to be aware of the funding, the nuances, the complexities of it. And I actually think that I'm a little surprised that the industry isn't moving towards pro-disclosure legislation, because I think the bright line rule would be easier for the industry, actually at the expense sometimes of plaintiffs, where whatever legislation we may end up with may be underprotected by that legislation. So I think that these sort of bright line rules can be over-regulating in some situations, under-regulating in other situations. Back to the same thesis.
And so some of this legislation that there has been success in state legislation, and I want to talk a little bit about Louisiana, because they introduced legislation last year. It was ultimately vetoed by the governor at the time, and then this year it was reintroduced. But there were two different bills. One was backed by the Chamber of Commerce and one wasn't, and the one that was not backed by the Chamber was the one that ultimately passed. So Daiwei, can you talk a little bit about your thoughts on this bill? It's much different than some of the broad ones we've spoken about so far.
Yeah, I'd say this bill is like well, you went to college there, is it an andouille sausage that we saw being made? So just in case anyone still has any kind of faith in democracy, if you're ever on the front lines of these things, you'll see, in law school, went to law school here, we talked a lot about legislative intent. The legislators don't really intend anything. They don't know what they're putting. Well, sorry, excuse me.
Except for the New York Senate and Assembly.
Yes. Excuse me. That was a crass comment. The sponsors of the legislation oftentimes have no awareness of actually what they're trying to legislate or the repercussions of it. Some of them. Sorry. There have been times when. Andrew should be speaking. There have been times when sponsors of legislation really they're not familiar with the repercussions. They don't know the issues. They're informed by a lobbying group who's given them a version of a bill that, in the case of Louisiana, creates massive conflict with Louisiana's own state law. And nobody even knew that until I pointed it out to them. There's generally it's as partisan as you think it is or as you fear it is. So we had a legislation being proposed, narrower legislation with kind of a different purpose was proposed alongside it. And then you saw compromises and lobbying and wrangling. But the reason I say that people don't necessarily know what's going into them, I mean, at the last minute, you had literally someone reading an article like, oh, well, actually, I think this is so curious. It's really similar to insurance, isn't it? And then you get into all the arguments of, well, there's no insurance on the other side. Insurance has control. Insurance has privilege. Insurance is before the event. This is after the event. There's no potential for prejudice. Insurance is meant to resolve things more efficiently. What you're talking about would drag things on until someone runs out of money. Not appreciating the nuances to disclosure, putting in rules that say, okay, even with the Louisiana rule, it's like, okay, well, you get the fact of funding, and then the funding is subject to civil procedure, trial court, what kind of, the rules of discovery, what kind of ambiguity does that inject? And when anyone writing it, were they aware of that, and was that the legislative intent? So what I really mean is the legislative intent at the beginning can transform and get shifted, but the end product may not have anything to do with it, and I predict what you'll see coming back next year is another attempt by the chamber to put in a more aggressive rule, because that's kind of the way that they roll. Generally speaking, I think we're seeing a couple states in play every year. We're seeing many states in play. And yeah, there is disclosure passed in some of them. I think anyone watching it, if they're thinking about national trends or anything like that, should think, well, what's the situs of these disclosure regimes? Is it somewhere where there's actually a lot of commercial litigation? Is it somewhere that, when Maya says we should be pushing more, pro-disclosure, well, we've got 50 states. We've got, federal level, that's incredibly expensive. And what we're doing is popping up whack-a-mole proposals in states where, honestly, like Louisiana, we don't really have a dog in that fight because of the litigious rights doctrine, right? So we're not going to be, priming lobbyists there and spending money doing that with the little money that we have. So there's, they're doing that in Missouri, in North Dakota, West Virginia, Wisconsin. I think it's important to think about, well, what were our dogs in that fight? And then we have disclosure regimes. What's come to light? Where's the data? Are people willing to look at that data? I think the federal study that was announced, it's going to be chaired by Judge Proctor, I think that's something our industry is really open to because we are pro-transparency. We'd love to advertise the cases that we're funding if we're going to come back and hurt them. I don't know if the defendants have thought that far along, though, to think, well, wait a second. Now that there's funding and we're not going to know how much there is, oh crap, we're not going to be able to manipulate the tilted playing field anymore. This is big ticket stuff. Maybe we didn't want to know that because now probably the numbers are going to have to go up. But maybe that's how you're going to think about it. I don't know. Maybe the defendants who have been saying, oh my God, there's all these cozy relationships between funders and plaintiffs' counsel, then they're going to realize that, wait, we have a relationship with your defense lawyer too. How do you feel about that? Do they have a conflict of interest? Be careful what you wish for. So I think we'd love to be shouting from the rooftops, and we're pro-transparency, and that would work wonders for the secondary market. It would help us, raise capital. It would do all sorts of things, and I think it would drive better results and more efficient resolutions. But we do need to get to that compromise place. And the states like Louisiana that have passed the laws, they don't really do a lot for that because there's no litigation funding there.
If I may moderate some of what I just said, I will say that litigation finance, especially litigation finance, is a relatively new industry. Burford was started 15 years ago, and we were walking into an industry that was really just starting up. A lot of legislators simply are not familiar with it. It is an effort to educate folks about what litigation funding is, commercial versus consumer, what the commercial finance versus litigation finance versus any other form that legal finance might take. The industry has some folks who are out there lobbying, educating legislators. The other side, the defense bar side, employs folks like Mark and many, many others like Mark to go out there and advance their agenda, as they should. That's what they do. And so we have been engaged in a more than 2 decade and a half long effort to educate folks out there. And that I think is why we sometimes see bills being introduced that don't have the benefit of full information because there just hasn't been as much education. This is not an issue that everybody is fully informed about yet, and we're working on it.
Can I go? On Louisiana, I wasn't involved in that, but it is a good jumping off point when we're talking about what's in the state legislation, because most of the laws that have passed in the states that were mentioned have been disclosure laws. Wisconsin was the first in 2018, and Wisconsin literally just says, if there's litigation funding, whether it's on the consumer side or the commercial side, you have to produce that agreement. That's sort of the most straightforward. West Virginia did that, Montana, but not for consumers, and then Indiana. So, but Louisiana was a bit different because it goes beyond disclosure. So as more is learned about the industry, there is a concern coming out of the Cisco about potential influence or control of the litigation. And so one of the provisions that is now in the newer, like disclosure 2.0, I guess, would be language that says the funder cannot control or have any influence on litigation decisions, including settlement. So that's language that's in the newer models being out there. And then the other issue, and I don't want to overplay it too much, but there is a concern about litigation funding coming from foreign adversaries. This seems to be from the political viewpoint where most of the legislators are interested. Is money coming from communist China to get secrets from American, proprietary trade secrets from American companies that could be produced in discovery? I don't know. I mean, these guys laugh at that, but it's created enough interest that Senator Kennedy and Senators Manchin introduced a bill about that. There have been a dozen state attorney generals that have written the U.S. Department of Justice asking them to look into this. There have been congressional hearings on it. There have been editorials by Donald Cochin, for example, George Mason Law School, in the Wall Street Journal. So they can laugh it off, and I don't want to overplay it, but it is a real issue. It's something that people are concerned about. I don't know how often it occurs, but it's a concern.
It's an issue you keep talking about, and that's why people keep talking about it. But tell me, Mark, play it out for me. How does China get trade secrets through a litigation funder?
Well, so I'll get to that. But the Louisiana bill says that if there's foreign funding involved, that has to be disclosed to the Attorney General. So a
I
different
think
way.
it's foreign funding from countries of concern.
Countries of
Yeah.
concern, exactly. So including communist China and some others. How does that happen? So, and I think part of this may be preventable, but there is a concern that is part of the due diligence, that as part of the funder trying to decide, do I fund this case? And how much do I put into it? What's my risk in this? Is they're going to have to look into what are the strengths of these cases, what documents have been produced, and the concern is that when the documents are produced to that funder as part of the due diligence process, they now have that information. Now, maybe it could be blocked. If I were litigating cases now, I would ask for a blanket order that either nothing goes to the funder, or if anything goes to a funder, it has to be protected under the same protective order that would normally
But that already
protect
exists, right?
trade
You already have
secrets in the
protective
case.
orders.
But that's, I just mentioned that because that is sort of the new disclosure 2.0 is trying to address that issue as well.
Just to continue to play it out, though, so I'm, as a half Chinese person, I am controlling litigation illicitly and on behalf of my ancestors, and so I'm doing that, okay, and I fund the litigation. It's a trade secret litigation, and I really want to get after these trade secrets. So first, I have to conspire with my investors to do this. I presume that's illegal. Then I have to conspire with the lawyers to get the information in contravention of the protective order. That's illegal too. Then I have to take that.
Lawyers are now at risk for
Well, let's
disbarment.
talk about.
Well, hang on,
it's a
and then
limited
I
of a
have to-
purple vine, because this is what's happened. There are patents being formed, that patent entities that have brought lawsuits against competitors, and
Korean
the
competitors.
company is from communist China, and the acting head of the U.S. Patent and Trademark Office, not the chamber, but the Patent and Trademark Office, said this is our worst fears confirmed, because anything that's given to Chinese companies can go to Communist Party. The party controls the businesses. So it's not me saying
Who is
this.
the
This is
defendant
the
in that
acting
case?
head of the Patent and Trademark Office said this is a concern of ours.
But who's
Now,
the
it's only
defendant in
come
that
out
case?
in 4 cases, so it's a limited subset. But again, there is a concern that this is a potential thing that could happen. Enough that Congress has looked at it, that they've introduced legislation in the United States Senate on it.
And Maya, how do we feel about regulating an entire industry based on that outlier?
Well,
Not to put you on the spot.
no, that's fine. I think that generally when we talk about what obligations should be placed on, I don't want to call it even obligations on funders, like how to deal with the issues introduced into a litigation once some kind of third-party funding is at play. We need to differentiate between 2 levels. One is, what should we legislate? And we should legislate based on things that we think are mainstream kind of scenarios, like control and conflicts of interest. These are issues that are going to come up often. Then there's issues of what might occur on occasion, right? And I think that foreign intervention by a hostile foreign nation is an outlier scenario, likely. I mean, we don't know, but I'm assuming that this is not something common. So should we have legislation about it? I don't think so. However, does any given defendant, or is it the case that any given defendant might have due process or other concerns in their individual cases, which they should have disclosure about, which might need to have some discussion before a judge, and so forth? Yes. So I actually think that I wouldn't laugh at it. I mean, I think that because of the broader point that there could be scenarios that are outlier scenarios that are nonetheless really important to the rights of a litigant, by the way, defendant or plaintiff in a given case. And I think this is one of the, I want to make a meta point here. One of the things that third-party funding has introduced and has been a concern, and I am in favor of third-party funding. I think we should allow it, but just be clear-eyed about the actual problems as opposed to like, oh, it's just a bad thing, has always been the commodification of legal claims and thinking about litigation or lawsuits as an asset. Now, lawsuits are in part an asset. It's totally fine if professional funders doing their job are like, okay, for me, this is an asset. But for the rest of the public, a lawsuit is someone's dispute about their legal rights and their legal obligations. And so when someone's legal rights and legal obligations are being adjudicated in one of the three branches of government, in an individual case, a defendant may have serious considerations that a judge might want to take seriously.
I think that's very important. I do wonder about the point, though, about what is independently unlawful. Like, take the foreign funding. And just an aside, this seems like something we could nip in the bud. You know what I mean? Like, you could pass something that just says, like we currently have, you can't have funding from countries of concern. What's the big deal? I don't think, like, legitimate funders who are funding most of the cases, because this is very expensive and you actually need a lot of money to do it, and not that many people can raise a lot of money. The people who are funding the overwhelming majority have no issue with this whatsoever, and that's why we laugh at it, because at a maximum, this could only be affecting a minority of cases in the courts, not to mention that there's plenty of instances of Chinese companies just stealing trade secrets from American ones, and we've funded cases by the American companies to stop the Chinese from stealing them. That probably is happening more than the other way around. I mean, just in terms of how big the sector is, and I don't use ChatGPT much, but I was curious what it would say. How big is litigation funding? It's grown. It's $15 billion under management. Well, if you trust our AI overlords,
Why would
they
you,
say
by the way? Okay.
it is still relatively small compared to major finance sectors when measured by AUM. While it has grown steadily, it does not rank among the top 500 sectors by AUM in the US. So this is still tiny. It's kind of like, it's a blip. And there's a lot of we don't know what we don't know. I think that gets old at a certain point. So then you get into points where, well, you have some state courts, like I've talked about Louisiana, North Dakota, Wisconsin, West Virginia. We don't have a lot of commercial litigation funding there. These aren't major commercial centers. So let's talk about a major commercial center. Let's talk about Delaware, right? There's a lot of funding that happens in Delaware state and federal courts. Obviously, this is kind of prime time for litigation funders. It's a key jurisdiction. So are you familiar with the study that the Delaware State Judiciary did on litigation funding? I'll give you a copy, but here it says, the recommendation, the committee has not identified any issues with the current use of third-party litigation funding in the Delaware state courts. The committee does not believe that substantive regulation of litigation financing is necessary. The committee believes there could be value in considering a court rule that would authorize limited discovery into third-party litigation funding and limit broader discovery on that subject. A rule could provide helpful guidance to litigants and judges in this area. For purposes of discoverability, they would recommend a rule similar to 26B2 on insurance, which would authorize discovery only regarding whether there is any arrangement that gives a third-party control. It would recommend that the rule not permit broader discovery into third-party litigation funding absent some additional showing of need. The committee would recommend that the rule make clear that some third-party litigation funding material, such as case analysis, is work product. This is signed by Judges Eric M. Davis and Vice Chancellor Travis Laster.
I wonder if they spoke to the federal judge in Delaware that has one of the most
They
aggressive
did.
funding disclosures
They
in the
did.
country. Who
And
has
they
said-
speak specifically about how Connolly's experience is cabined to a certain type of patent litigation and should not be broadly interpreted as anything indicative of overall trends in the area. So I recommend, this is kind of the problem though. We have proponents of disclosure saying, we want transparency, we want disclosure. We've got all these instances of disclosure, data points, facts, DNJ stats that Andrew and I track religiously. We're ready to come forward with data if we need to, and we've been tracking every mention of this and pointing out how it's not an issue in 99.9% of the places where it comes up. Then actual studies are done by judiciaries that are interviewing other jurists, federal and state, as well as litigants and parties in those courts. And they're also finding that there's no issue here. We have the GAO looking into it. How many times do we need to do this? We don't know what we don't know gets a little old at some point. I'm just wondering, you know, if there's going to be a change. Like, this approach recommended by Delaware is exactly what I said at the beginning, is if we have something down the middle, we can agree on a compromise. Maybe we can just move past this. But I think this kind of gets back to what the defense bar goal is here. Are you going to stop, or is something like this going to be okay with you that addresses the concerns that you've actually articulated?
Compromise has to be on both sides.
You know, you've raised a lot of different points. I think, you know, if you look at what Wisconsin did in 2018, it's been out there for half a dozen years now. It's a straight disclosure bill. There hasn't been any effort to go back into Wisconsin and do something different or more. So I think, you know, The Chamber and Lawyers for Civil Justice have filed many comments with the federal judiciary over the last decade to try to get a federal rule. There have been legislation, and they're all pretty straightforward. I mean, there is transparency on our side of what they want. They put them in comments and they say, here's what we want. We want disclosure, and here's the reasons why we're asking for that.
Well, okay, those are the reasons you state. Is it not also true that one of the unstated reasons that you want more disclosure is to increase the cost of funding? You want to make it harder for folks to get funding. You don't want to ban it outright, but you want to make it harder for folks to get funding because you think that funding is generally bad for your constituents. You think that generally you're on the defense side and that funding is generally on the plaintiff's side. And so if you can make it more expensive or harder to get funding, that's good for your clients. Is that not, I mean, is that part of it?
No. I've never heard anybody say we want to do this to raise the cost of doing business on the plaintiff side. And there's a lot of suspicion on the defense side that this money is going to not just fund litigation, but to create it. And I'll get in. I wanted to raise a point with Emily because this goes into sometimes we hear from funders that we would never fund frivolous cases. We're in business, to make good decisions, to make good investments. We would never fund a bad case. But on the defense side, when we're talking about the mass tort context, when you look at the MDL context, a huge number of the cases that are in our MDLs are unsupported claims. They are frivolous cases. They're either cases where the plaintiff never took the product that's at issue, they don't have the injury that's at issue, or that their case is time barred. And it is funding that is going to prop up a lot of the mass tort litigation. If you look at the dollars that are spent on television advertising, for example, they track the amount of money that's going into TV advertising, roughly $1 billion a year on legal services ads, and it's gone up like this. And if you were to compare this to when funding started in the United States, it tracks almost identically the track of increased spending on television advertisements. And what effect does that have? When you look at some of our bigger MDLs, I'm working on a paper right now, in the Mentor Corp transobiter sling product litigation, 75% of cases dismissed. 75% of the cases in the MDL dismissed. If you look at the Ethicon pelvic mesh litigation, 53% of cases dismissed. Zofran MDL, approximately 40% of cases dismissed. So it is going to fund frivolous litigation. It is going to generate mass tort litigation that is not fully vetted.
Can we talk about commercial though? That's
Well,
I don't think that's this panel.
I agree.
Well, it's a commercial panel, and
how
this is
about-
the commercial.
Yeah,
This is what.
But we can respond to that because
Commercials.
leaving
Commercial
aside,
It's
That
like the
too.
asylum.
Yeah.
The asylum.
leaving aside whether Daiwa and I actually fund that kind of litigation, I think there's a broader question about what the rules are now about filing cases in these mass torts, right? You file it or you lose it. And I think there may be, again, this is not my area of expertise, but is it not possible that folks are simply saying, I don't know whether I'm in this lawsuit or not. They're getting signed up by lawyers who also don't have access to that full information. They know that if they don't file a claim by X and such date, they're not getting into it. I don't know whether that's possible. Maybe it is. But I will say that if I'm a funder and I pay for somebody to acquire that claim and that claim is zeroed out, I'm not getting paid. And so I'm not going to say that there's no way for that to happen, that there's no way for funders to make bad investment decisions. But
I'm not saying it's a bad investment decision, because what they're betting on is if I file enough of these lawsuits, even though many of them are going to be dismissed or I'm going to lose, I only need to win once in a while. And I'll give you an example of that. In the J&J ovarian talc litigation, for example, J&J has prevailed in 95% of ovarian cancer cases tried by the middle of this year, okay? That would tell you that these are flimsy cases, that they are speculative cases, that they are cases that don't have merit, when juries are saying 95% of the time, this is not a legitimate case. But the one verdict in Missouri, $2.12 billion. So what does that tell funders? It says you can go fund 20 cases out there and lose 19 of the 20 cases if you're going to get $2 billion on the 20th case. That is what is continuing mass tort litigation, and that is a concern on the defense side, is that this is generating flimsy litigation, frivolous litigation, because you don't need to win all the time. You only need to win once in a while.
I'm going to tell you something you probably don't want to hear, but I think what you're describing on the tort side, and again, I encourage you on the commercial panel to try and give responses that relate to commercial, because I think
commercial.
Well,
this is
commercials.
money going to law firms to fund litigation.
Okay, commercial litigation. How about that? Not tort litigation.
Fair.
Not injury litigation.
Well,
Commercial
then you
litigation.
guys got to
What
jump
we
on the
do-
bandwagon, because the mass tort side of your business is giving you a black eye, right? It's the mass tort side of the business and the patent troll that is really generating all of these.
So let's stick to the commercial side of the business. And I mean commercial
I get it.
litigation.
Business to business.
Business to business,
Right.
things that aren't torts. But just so I encourage you, stick to those responses. 'Cause you can go off all day about torts. We could respond to it, but that's not what we're here to do. Like the Federal Rules Committee is looking at a rule that's going to apply, not just tort litigation, but commercial is a huge part of it, because the disclosure concern in commercial is prejudice. In mass torts, you don't have the same types of communications. I don't think it would be very exciting for a defendant to get communications between some lender and some law firm about marketing budgets. Like, who cares? And it's not like there's going to be communications between the funder and someone who's been injured who they're not in privity with, where there's going to be sensitive things that we're scared about come out in discovery because they could be used to pigeonhole someone in their damages claim. That's what happens in commercial. Those are the concerns there, and they're real because they're subpoenaing us. They want all the communications, emails. They want to depose us for these reasons. It would be very different deposition questions on the tort side. The thing you probably don't want to hear is, it's not my business, but it sounds like there's probably not enough funding in the tort side. It sounds like people are taking money for marketing, but what they really need is a lot more funding to vet cases, and there needs to be more money there in order to whittle it down. But I don't think you would.
Lawyers are supposed to do that before they file.
Well, again, and that brings
Right,
us
we
to
have rules
that
about
brings us to
Rules
Andrew's.
Lawyers are
Limit,
supposed to
right?
do
Right.
their own due diligence before they file lawsuits, but it doesn't happen in the
But
mass
so is
tort
that the
context,
funder's
because they don't even
problem?
know the clients. They've never met them.
Okay, that sounds like a legal ethics issue. It sounds like an MDL management issue, which I think the federal rules were just amended to partially address. I mean, this feels like something that is being addressed elsewhere. Again, not a funding issue, certainly not a commercial funding issue.
Well, I do want to say that, the International Legal Finance Association, which is your trade group for commercial legal finance, also includes members who are pretty active in mass torts. Mass torts have increased a lot in your industry over the past couple of years, so there is this conflation. Do you think that these two industries should be separated completely? And do you think that would involve having two different trade organizations? Do you think this should all be approached very differently?
I think that it goes back to Maya's earlier point, which is that we have a lot of different situations. Legal finance is not a monolith, right? It's not one thing. It's not just commercial. It's not just consumer. It's not just mass tort. There are a lot of different aspects to it. Lots of different ways that legal finance happens. And I don't think we should be regulating legal finance as a single thing. We should be looking at the ways that legal finance interacts with the legal system and say, okay, where is the behavior that that we're concerned about? What are the effects that we're concerned about? And what do we need to do to regulate to those potential bad effects? And so in the mass tort context, there may be things that you want to do. You might want to look at this new MDL rule. How is it being rolled out? Is there a need for a broader disclosure of finance, not just in the litigation side, but in the aggregation? I don't know the answer to these questions because I'm not that guy. And doesn't, as to your structural question of whether ILFA needs to be divided up more, that's a question for ILFA's management, not me. But I think that there are different concerns for different parts of the market, and consumer folks have different issues from commercial folks. Sorry.
So, no, I don't want to.
Go.
So what should be regulated with respect to commercial funding? Assuming there should be some happy middle, and nobody needs to accept that assumption, maybe there should be, but if there is, what regulation would be reasonable, targets behaviors that are problematic, meets whatever criteria you're advancing for proper regulation.
I mean, there, I think you already have regulation, right? You already have the courts overseeing their dockets. And for the most part, you have judges looking at situations as they arise and making decisions about what additional disclosure is required. Should there be discovery into the funding agreements in, for example, in patent cases where issues of patent standing and valuation may be more relevant than in any other commercial case. So I think that you already have a type of regulation in place. Is there the need, as Mark would say, well, I don't know, the judge doesn't know when there's funding in every case, and so they don't know to look at those issues. Should there be some sort of additional disclosure of the fact of funding, but that's it, beyond show of good cause, as is sort of the rule in New Jersey and Judge Connolly? Maybe that's a way to go. But I don't think we need broader, there's not a consumer protection type, we don't need to protect the commercial counterparties in the same way that you need to protect consumers. The courts already have their inherent powers, and we sort of have struck that balance between adverse parties to say what you get and what you probably shouldn't get under doctrines of work product and the like.
But I think if there were a proposal that were narrowly tailored and limited, you'd see significantly less objection or resistance to it. I can't speak for the industry, I can speak for myself and where I work, but there are some folks who are like, well, why should anyone get anything? The judges say they don't get it. It's irrelevant. Interprivilege just creates sideshows. There's all this potential for abuse. Realistically, we want to move past this. If Mark came and said, okay, well, I hear you guys. Yeah, this prejudice thing totally resonates with me. I get it now. Thank you for having me on the panel. How about this?
On the plane
How about this? How about a rule which says, we do basically a 711 disclosure, and it says, and anything else or anything potentially prejudicial.
About District of New Jersey.
District of New Jersey, thank you. Anything that could be prejudicial is off limits, because the purpose of this is determine whether or not there's conflicts, whether or not my Chinese ancestors are pulling the strings, whether or not, whether or not there's control, and if there is control, I think actually people differ on whether they think control is okay and where the line is drawn. I think if you read some of Maya's, Professor Steinitz's here's earlier writings, you'll see that she actually is pro-control to a certain extent, and I actually quoted some of that when I wrote the counter-narrative to the Cisco story that you've been telling, which I would also recommend you read along with this on the plane home. But I think if there was something narrowly tailored like that, we could totally have a negotiation. The problem is you guys suspect there's all this potential foul play. We suspect what Andrew said, that this is really a Trojan horse meant to just be another line of defense in the defense playbook to make things more expensive, inject tension between plaintiffs and the funded parties, whatever it is. So if there's something in the middle, I think we'd love to see that. And again, I personally am pro-transparency. We disclosed in a case last week. We're funding Atlas Data Privacy against hundreds of data brokers, 150 lawsuits. We disclosed pursuant to DNJ 711. We said who we are. We said we don't have control. And that's the end of the story, because that's a good cause for further disclosure jurisdiction. And I think we're happy to do that. It's generating lots of good press and investor inquiries. So we'll keep doing that. But where it's required. And I think if we can get to that space, just be careful what you wish for, but that wouldn't be such a bad thing for us.
So can you talk about how sometime where there is disclosure, like New Jersey or Delaware, are there instances where funders have been sort of pulled into sideshows with it? Has it had any negative effects for you or your peers? Can you talk about some examples, either Andrew or Daiwai?
The typical example is just third-party disclosure requests or discovery requests, and this happens now. It's just a matter of course. And I will say there's a limited number of interrogatories of deposition requests you can file, but we've certainly seen that number increasing. For the first 10 years, probably maybe we had a couple of cases where we were disclosed and we were sort of pulled into sideshow discovery litigation, and now it's happening pretty much. I'm not going to say all the time, but with increasing frequency. And we have responses to that, which is, generally speaking, if you're just harassing a funder by asking for information that you could have gotten from the party, that's not something you're supposed to do. If you're asking for material that's simply protected, work product protected, or just doesn't exist, and we can answer those fairly quickly. But it is an increased cost, and it's just it's not making things more efficient. It's certainly just running up the tab.
Well, I'll give you some bad news then, that Lawyers for Civil Justice is going to start a new program and a website called Ask About TPLF. So if you're not getting it in every case, that means the lawyers probably aren't doing their job.
Isn't that kind of a waste of the defense money asking for it when the odds are stacked against you that you're going to get anything?
Well, I think that
wants
it
to
has to
increase
be
their
more
bills.
surgical. Some of the defense requests that I've seen are just, we want it because we want it, and the judges have not been receptive. The case law says you don't get it just because you want it. There's got to be some reason for asking for this. Something that's kind of smelly going on in the case, fishy, potential conflicts and things like this. There's a body of case law about how lawyers need to be more surgical when and how
More
they
than
ask for
speculation.
this, right?
Yeah. Which is it's fair, and hopefully in none of our cases is there going to be more than speculation about what's going on. But it does, as Daiwei says, it increases defense costs because they're putting together new interrogatories and deposition requests. If they are, I mean, we've certainly gotten some requests that are just actually copies of the party requests, and you're like, okay, we can simply object to these because none of them make any sense to us. But you are going to increase costs on both sides.
Mark, are you aware of how the result of these discovery requests, do they often get the things they're asking for?
No. And that's why, the case law, because the judges that are looking at the current rule on discovery, the issue at Rule 26 in the federal rules, and most states have the same rule, is that the discovery's got to be relevant to the claims or issues in the case. And so, unless there's something suspicious, some conflict going on, or it goes to the bias of the person bringing the lawsuit, or a bias that they may have, or that witnesses may have. In those narrow situations, the courts have said, okay, we'll allow discovery to go into those issues. But generally, you can't ask for third-party litigation funding information and just get it because you want it. And that's why, because you can't get these things through the normal discovery process, that there has been this effort going on for years to ask for a federal rule to put it in the federal rules, or through legislation such as Congressman Ice's new bill.
So do you think that if they're...
Well, But let's just be clear. You're not asking for discovery. You're asking for initial disclosures of the funding agreement, which is different, right? The request in Representative Ice's bill, that would be an automatic disclosure of funding agreements. That is something we're never going to agree with. We are at least willing to talk about, in what circumstances is a funding agreement discoverable? And that's, what we're seeing in some of the model legislations being drafted, saying, okay, funding agreements, the fact of funding, automatically disclose that. Funding agreements may be subject to discovery under the existing rules of work product. Okay, if it's clear that that's true, I'm not going to say that we're going to be super thrilled about that, but we just don't want initial disclosure, which is outside the work product protection, to sneak around what we already view as work product protected materials.
Yeah, I've always been puzzled why you guys weren't the first on the bandwagon to call for disclosure, at least of the fact there's funding in a case. Because if I were a personal injury lawyer, the first thing I would tell the defense is I'm funded in this case. There's not going to be a day where I'm going to run out of money.
Well,
There's not going to be a day where if I get a judgment, I don't have the money to go out and get the best and the brightest appellate lawyers to uphold that judgment. I would want the defendant to know that.
But
So-
we're talking commercial again. So on the
Right,
personal
well,
injury side, the consumer funding is about living expenses, not
No, I'm
lawyer
not talking
expenses.
about, I'm talking about money going to a personal injury lawyer to fund the prosecution of the case. The case could be a patent case, it could be an antitrust case, or it could be a personal injury tort case. That is commercial funding. It's not, the underlying lawsuit may not be a commercial lawsuit, but commercial lending includes giving money to plaintiff firms for prosecuting litigation. And what I'm saying is if I were the personal injury attorney who got money from somebody in your business to fund this litigation, I would affirmatively be telling that to the defendant.
I think that's an interesting point, because one of the purported justifications for disclosure sometimes is we want to beat back what's a false David versus Goliath narrative. And the defendants like to say we should have disclosure for that to show this isn't really David. David has a rich uncle. And fine, but the counterpoint of that, and I've actually done some research on this with jury consultants, is that actually more jurors think that David is more sympathetic because David had to get funding. So I think you're saying something that doesn't quite toe the party line, so just beware there.
No, I understand where, I mean, I'm just saying if I were a plaintiff's lawyer where I would come at this. But I get it from your side why you may not want to do that, because as you point out, it does lead into, cost shifting. Because in discovery, we have the producer pays rule in the United States. Usually in the tort context again, I'm not talking about large businesses suing another large business, but in the tort context, the producer pays, meaning if you have a personal injury plaintiff suing a large corporation, the corporation has to shoulder literally all the expense of discovery, because there's very little to discover on the plaintiff's side. That's the defendant that's going to be producing 20 million pages of documents. And so it's all there because traditionally we've looked at it as, wow, do you really expect this widow to take on this large corporation and pay for production of 20 million pages of documents? I think that calculus changes and should change now when you find out that it's not just the widow, but she does have a very rich uncle. And so that the parties are essentially equally funded in this litigation, and it should open up a conversation about whether the plaintiff and the funder should help fund some of the discovery that they're asking for as part of their investment.
I think that's a bit of a distortion of the proportionality requirement under Rule 26. I mean,
It
if
is
it's
under
put
proportionality,
if it's
but
put
there
at issue, if someone claims poverty and they have funding, okay, maybe that should be relevant.
26C in protective orders says that expressly provides for the judge to allow for cost shifting. And so this could be an example or a situation where more judges need to look into this.
Can I
Okay.
just note here that disclosure and admissibility are different
Yeah,
things,
fair.
right? And so the debate and the bill is a disclosure bill, which I think is overbroad, but it's a disclosure bill. It's not an admissibility bill. Arguably generally what's discoverable is much broader than what's admissible. So I just don't want to confuse the audience that even if this bill passes, it doesn't mean that the jury will ever get to hear the fact of the funding or how much and so forth. And the other is I do want to amplify something you said, which is behavioral studies show us that even if something is admissible, it may not play out at all the way that we might assume in advance. So it actually, as a scholar, I would be curious to see if it ever gets not just discoverable, but also admissible, how it plays out in front of the
And I
jury.
want to say, I think what I say is consistent with what you call the party line, because my gut would say, well, why wouldn't the plaintiff disclose the fact that there's funding in the case? Because it would seem to be in their interest to do so. So if the plaintiff isn't doing that, it does lead to questions on our side about, well, they don't want to disclose that because maybe there is control in the case by the funders. I don't know that without looking at the agreements, but it does when somebody, would seem to be in their interest to have disclosure and they're unwilling to do that. It does lead to questions about why. What is it that they're trying to hide? Why don't they want this information out there?
So let's just go. So I think we're being a little unrealistic here, because if we did that, and we'd be happy to if it didn't create risk of prejudice. We keep saying that. Are you offering a situation where we can come to you and say, we have funding, we want everyone to know about it, but no, we're not going to seek anything prejudicial or work product. We acknowledge that's out of bounds and we create an unfair advantage for the defendant. If you agree on that, we will tell you all the cases we're funding. And we will tell you we don't have control, but we'd love for them to settle because we don't want things to go to trial. We could shout that from the rooftops, but we need assurance from you that we're going to be safe. So will you guys propose some legislation or something limited which says, what I think you've acknowledged in the case law, which is that you need special circumstances or special need to get it. You don't get it in just every case. Yet that's what the overbroad legislation provides. So what's the answer here? Because I think if you don't understand where we're coming from, I think hopefully you're listening, because it's very clear. We don't want to hurt the cases, because I know you think we're in the business of investing in frivolous litigation. We're not, and we especially don't want to invest in good litigation that then we create a new defense for. just because
Or
the
just
thing
increase
needed
costs.
financing, or just increase costs, which increase costs on litigants. It's just bad for everybody.
Well, do you think that potentially you can all work together? Like, is that I mean, I know you all are talking around it, but could you propose model legislation? Could you work with the Chamber of Commerce? Is that something that, have there been discussions about that?
I think it comes down to, you might think yes, but then I'll go back like an hour or whatever it was to when Mark said, and we'd want to see the agreement. We want to see how they tranche it out. We want to see all these things that could potentially be perceived as direct or indirect control. If you get there, then it's no, right? Because that shows that this really is a Trojan horse meant to uncover prejudicial things. If that were just in camera, if they would agree to that, then maybe we're talking, but I think it's pretty telling that they don't.
Well, and the latest from the chamber is that in camera is an extraordinary measure, and the committee should not ever allow for in camera review of these documents because that doesn't get us what we need. So I think Emily, I think I would love if we could have some sort of grand bargain, but I don't know actually who the negotiating parties of that are, and given that this is going to happen in either whether it's through legislation or court regulation across 50 states and the federal system, it may be challenging.
And we'll never get there if we keep conflating torts and commercial. Like, we're on a commercial panel here, and torts have come up like 95 times. So like,
I know,
if we
but
keep doing that, we'll never get there because it's not an honest dialogue.
I just want to, if I may say on this, I completely agree that commercial and mass torts are different things. However, as commercial funding through portfolios becomes more and more effectively the funding of law firms, we need to acknowledge that we need to rethink how we're thinking about all of these things. That's an issue for where's David, the next conference. But it opens up a whole other issue. But I just want to say that it's not. I agree that commercial and mass torts are different scenarios. That said, it's much more complicated, and commercial is starting to look more like what's happening in torts in some situations, given that these are both becoming increasingly mechanisms for funding law firms.
Well, that's why I was saying let's look at the effects of funding, and let's regulate those effects and not regulate an industry in a way that doesn't actually get at the behavior that we're concerned about.
Like, do you acknowledge that the disclosure concerns are very different for tort and commercial? Like, one has substantive, potentially prejudicial communications and the other doesn't?
I don't understand how you mean prejudicial in this context, because for me, prejudicial would be the admissibility issue of whether a jury should hear it, and I agree that there's probably few situations where there's legitimate reasons because a juror would be prejudiced by hearing about the rich uncle. But I think you're using it in different.
I mean, here we're talking about funding agreements that are, we're taking a big step back now. Funding agreements build in all the economic terms of the arrangement based on the diligence that the funder has done with the counterparty. And that includes discussions with, whether it's a client-side deal with the client and their attorney, or if it's a law firm-side deal with the law firm about the case that are going into portfolio. It reflects we need candor from our counterparties so we can underwrite the cases properly. And so it reflects legal opinions, it reflects legal strategies. We bake that into the agreement because our agreements are non-recourse, which means that we have to sort of make our investment and then we're along for the ride. And if the cases lose, we lose money. I promise you that is true. And so we want to make sure we've done as good a job as we can, not just doing the diligence, but also building into the agreement whatever economic terms make sense for the underlying litigation. That means that if you hand that document over to the other side, they see when funds are available at various stages or various times in litigation. They see what the economic terms are of the payment terms. They know when there are upticks in the amount that the funder receives as a total part of the proceeds of the litigation. They see, is there a trial kicker? Is there something that happens, after the end of the discovery? They will learn more about what goes into what the perception of the legal risk is based on the discussions the funder had with the lawyer. And that is all stuff that has been core work product, for as long as we've had work product. That's why we don't want to hand those out. It's not prejudicial to the jury, it's prejudicial to the case overall, and it is information that we would not hand over to the other side, but for the fact that it's a funding agreement that they want.
And there's also if you ever look at a subpoena, I can send you one after this, you can just see the 50 topics that they want. But you can imagine the amount of money in the budget. It's not just, that's extremely material, especially in circumstances where you do have a plaintiff who really needs the funding. There's plenty of plaintiffs who could fund it themselves if they needed to. And by the way, just to your point of, oh, well, the funding might stop. When a funder agrees to fund a case, the litigant still has an obligation to proceed.
Right, that's why I think it doesn't stop, because the litigant is going to go forward with that case. What they're gonna do is do what they need to do to keep getting the money. The control is there because the litigant is already in, they've got the case, they've got to represent the client, so at that point, you got them over a barrel. They have to do the litigation the way that you would suggest, because they've got an obligation to keep going.
I think your point, may resonate with certain of your constituents, but is overwhelmingly rejected by the case law and anyone who's thought about this.
The discoverability's been rejected by the case law,
Well,
but that's again because that's controlled by the rule, and that goes to
Well, it goes to relevance, doesn't it? But
to the plaintiff's claims or issues.
Just on prejudice, because I think it's important. If you of all people are not hearing everything we're saying, we need to be clear, because you study the space and you've been doing it a long time. The prejudice is the budgets, the returns, the representations and warranties that are specific to the case, anything that can be used to inject trouble in the funder-funded party relationship. There's any number of ways that this could be misused, but I'll show you the subpoena. It's not just the agreement. It's all communications. It's all notes. It's with funders. It's with potential funders. Because what do they want? Well, they're looking for emails where we say, okay, well, what potential ranges of damages could you have? What's the low? What's the high? And why? What are the weaknesses in your case? How do you respond to this statement by the other side? Anything that could be used against them, they will ask about it in depositions. Trust me.
And it may be because Mark suspects that funders are just talking to potential claimants and saying, hey, you got some claim that we can make out, make it past Rule 11, make it past motion to dismiss, but you don't think it's a real good case, right? Like it's a crappy case, but it'll scare the other side enough to get a good settlement, right? I don't know any funder who has done that kind of thing. I don't know why they would do that, and I don't know that they would make enough money over the course of a short period of time to stay in business. It's not a viable strategy, especially because you can try to bluff your way past motion to dismiss to get to a settlement, but the second that that bluff is called, you not just bring down the funder who's made a bad investment, you're also bringing down the lawyers who brought a Rule 11 sanctionable case. And I don't know lawyers who are willing to take those bets either, not and risk their license.
I'd say the flip side is, if we want to look at prejudice, just so you understand it, can we have the communications with the defense lawyers? Can we have some privilege? Can we get into that? Can we get the defense work product? Can we get the defense budget? Can we see how much money there is in reserve for settlement? Can we get the communications with the insurer after they've assumed the duty to defend, to the extent there's insurance? No, right? For obvious reasons.
You do have to produce the policy, yes.
Yeah, you have to produce the
but
policy.
that is a snapshot of the policy limits, and it's not this type of detailed information you're going to get from our agreements. And it's before the event versus after the event.
We've got to go to questions.
Yeah,
soon.
I just
Sorry.
want to say, for
I had
final
another
question.
point too, but I wanted to.
Yeah, because we
respect
do want to
Emily's.
have people ask questions, but I want to say, we've talked about the Rules Committee. Judge Proctor said that the last subcommittee he chaired took 7 years. So that's not going to be a quick solution. I know that everyone seems in favor of it. In the interim, we do want to leave room for questions. Do you want to add anything else about that we haven't discussed yet?
Well, I just want to, on that quick point, I think it's a very significant step that the federal judiciary has now created a subcommittee to look at this. Because for many years, and I think still among many judges, there's a feeling that this isn't happening because they haven't heard about it. And the defense side has always been shouting, you haven't heard about it because it's been in secret. And so it's a catch-22. How do we present evidence that this is happening when it's all behind closed doors? So I think that the fact that there is some recognition now in the judiciary that this is, at least in the mass tort context, probably happening in every one of the cases, enough that they've formed the committee is a first step in understanding that there is something out there, that this is happening, and we can't just assume that it doesn't exist or it's a small issue. The other one I wanted to raise, and I'd be curious, is where do we go from here? What does the industry look like 5 years from now? And this is a question I raised. Tony, last week, has a new book out, so I'll plug his new book on third-party funding if you have a class. But the question, I think, on the defense side about where does this go, one is, as an economist, I start thinking about the amount of money pouring into this space. At some point, whatever the figure is now, $15 billion could double by the end of the decade. At some point, we may have a situation where there's too much money chasing too few good cases. Maybe you're there closely. So as an economic actor, when I know I've saturated my market, how do I keep growing my business? At that point, I have to expand my market. And so I think that there's a concern on the defense side that where this goes is that funders go from being the passive investor, as you all have said, to changing the rules. And Tony gave some very good reasons why he doesn't see that happening, but that's a concern on our side. Maya's written, I think you were the first to write about that this could lead to changing the rules. When you have a $15 billion industry, they have more money to throw at changing the rules than the defense side has to preserve.
Whoa.
Yeah,
Come on.
I think so.
Come on.
Do you know
What's
the difference?
Chamber's lobbying budget?
It's not $15 billion.
Do you know about GPs versus LPs? No?
No.
The assets under management are from investors.
Right.
The GPs, the fund managers, to the extent we want to participate in public policy, that doesn't come from the $15 billion. It comes from
Well, the
the...
Our
companies are
operating
big
budgets.
enough to support, I mean.
How many
to
people work
fight.
in this industry in
So
the
you
US?
don't
Like
think
200?
you don't think there's any chance that the industry will start seeking to work with AAJ to expand new causes of action, repeal caps on damages? or
I
anything
love
like
that idea. I love
I'm just
it.
asking.
I think there's no chance in the next 20 or 30 years that we will be close, even the slightest bit close, to the amount that the chamber,
No,
ILR,
but do you see
LCJ,
the industry moving in that
every over
direction,
50
though,
state
working to
organizations.
lobby to expand
No.
laws?
Well, if you guys stop wasting our time
we're
with all these
defense-
proposals,
Right.
like the only reason we're talking about this is because you guys keep writing letters to the Federal Rules Committee and writing articles and creating websites. If you guys stop doing that, no one would be talking about this. But you keep doing it, and so we have to keep beating back this whack-a-mole. Yeah, if I had all this money to burn, yeah, I'll go repeal Section 230. I'd be rich, right?
Can I just bring this full circle?
Yeah.
That when this industry emerged, the argument was that it will increase access to justice. And part of increasing access to justice is actually looking at types of claims and causes of actions that are not being brought. I mean, there's an argument that we're an overly litigious society that's being debunked very well by a lot of scholars. And there's generally there's a correlation between amount of litigation and rule of law and economic development. So litigation is not, having a lot of litigation in society is generally correlated with good things. There's some types of litigation that if we see more of that being brought because funding exists is actually a good thing. And then there's there's types of cases like creating portfolios that are too large and MDLs that are too large, or there's a few good cases anchoring a portfolio or an MDL, and on the backs of those few good cases are not good, frivolous cases. That's where we don't want to see an expansion, but there are types of cases where we do want to see an expansion. So if I were in, for some weird reason, I'm giving advice here too. But no, if I were the industry, there's a duality here of saying our existence doesn't increase litigation. Well, then it's not creating access to justice. If it is creating access to justice, then the entrance of funding we should see more litigation. It's just hopefully of good cases, not of.
Right, I mean, to the extent that funding provides a screening function, it should actually decrease frivolous litigation because it's not going to get funded. It should increase meritorious litigation because it is getting funded. That may lead to a net increase or decrease in the total number of litigation out there. Frankly, though, I don't think that our industry is having a measurable effect on the number of litigations in the United States at all, right? Like, we are too small to be having that effect.
I think it's really, I mean, what we're seeing beginning in the mass tort, and we're going to see more litigation, I think, being funded. I think we're going to see more funding enter into this space as it becomes easier. This is not a difficult form of funding to replicate compared to some others. So I think we're going to see an increase and hopefully of some good cases where there's barriers to justice, but also of not very good cases. But the other thing I want to say is, yes, with respect to the numbers that you brought before, the industry is small compared to the American economy.
Mm-hmm.
It's large and growing quickly compared to the effects that it's having on the justice system. It's having profound effects on the justice system and on the legal profession. Some of these effects are good and welcome, and some of them are, I think, problematic.
So I do want to leave time for questions. So does anybody have questions? Yes.
Hi, my name's Erica Levin, and I'm at Fox Rothschild.
Sorry, Erica Levin, Fox Rothschild. First of all, I want to commend you on an excellent panel. You guys have been entertaining, informative, it's been great. And I know the disclosure discussion is old and tired in some respects. One aspect that we haven't broached is who pays, who should pay. To disclose or not to disclose, fine. I think most of us will agree some level of transparency is actually helpful. And to the extent we have some rubric that is predictable, okay. The problem, however, is in the who pays answer. Why? I negotiate a lot of these transactions. I've seen over time the who pays question gets very complicated, and it's just not the discovery burden. There's review, there's the back and forth, what should be given, what shouldn't be. And I want to introduce a concept that is really relevant to this discussion of commercial disputes. Why? There's this concept of an efficient breach. There's a concept of what you can analyze and assess a case and what the recovery will be. And when you have a discovery sideshow, that affects things. There's an amount that is attributed that does make sense to inject, and candidly, there are a lot of cases that are not brought because that number, unfortunately, is not enough. So we have another issue. That's for another day, Eric, another panel. But I'll leave you with the question, or at least the invitation to discuss who should pay, right? Because the plaintiffs, the claimants, are getting a set amount of money if they're getting money. There's not enough there to fight this discovery sideshow, and it shouldn't be a sideshow. So I guess that's pretty much my question and comment, and I invite those that are considering this to also think through that, because there are important ramifications to the access to justice that come through that. That's the other side. So thank you.
I think as Professor Glover originally coined the term, it's a tax on litigants. I think the litigants pay, but often through the funders because they can't afford to. I think we're one of the only funders that does not cap our capitalized expenses for fishing expeditions. If you probably haven't seen a funding agreement, but it's not like.
No, I'm like.
It's not like, but I do encourage you. Go on Edgar, search for the names of well-known litigation funders. You'll find a bunch. You just have to do the work. But we don't just say, here's an open checkbook, we'll write you unlimited money for the rest of the litigation. These are highly negotiated things, right? And one of the things to negotiate is the capitalized expenses of the funder, for whatever its costs are. And those can get woven in, there can be a return on them. In our agreements, there is a return on them. It's money that we put out, and we do have an unlimited amount of money to fight disclosure just because of the harm that it could do to a case. So the litigant pays sometimes 3 times that much.
Or you could send me one.
I'm
Just
happy
redact
to.
the name of the company and the amount of the
I'll
interest
reject
rate.
everything potentially prejudicial.
I'll get a redacted document that'll have one line at the top and all black lines.
It'll be like your defendant's discovery responses.
Yeah.
Question for Professor Stein. So, thank you. I think the first. I was just going to say that the first article I ever read on funding was yours about coming up with a model. Coming up with a model litigation funding contract. So you wrote that paper, and I found it very interesting today that you talked about leaving it up judge by judge for discretion. So that's like kind of a big swing, you know, I think a little bit on the other direction in terms of how we think about funding. And you talked about the risk of commodification of, you know, these cases. And so the question that I have for you as the professor on the panel is, I'm surprised, you know, in previous years of this conference, you know, we leaned a lot on Tony and discussions about the ethical rules kind of overseeing the courts. And I'm just very curious your thoughts on this idea that, with no offense to the legislative representative in the audience, you know, the three branches of government and why we're here now talking about legislation having to do with the judiciary. And I was also very curious because Emily asked the question about, well, do you think that we could ever come to an agreement with the Chamber of Commerce? Why are we talking about the Chamber, you know, as kind of the, you know, we're talking about the three branches of government and how decisions are made. And you know, I know the Chamber plays, and I'm not an idiot, plays an outside role here, but it's just interesting that we talk about coming to an agreement with the Chamber when that's really not a governing body of anyone. You know, we elect legislatures, you know, we have a judiciary. So I'm just curious your thoughts as to why we're here and how do we get out of, you know, the legislature in the courts, really.
Thank you so much for that question. I think it touches on some of the profound issues in this area, and it's just beyond the scope of this panel. But since you ask, my forthcoming book speak to this. But I do think it's one of the most profound questions because one of the things that we hear a lot is we don't need to regulate funders in the funding industry because lawyers are regulated. So first, for the lawyers in the room, question mark, how much is litigation funding risk shifting for law firms versus how much are you actually absorbing the risk? But I leave that to another day. But the problem is that the regulation of lawyers is not, bar associations as regulators, they're not like the SEC. They're not sitting out there saying, we have a mandate to, on some level, be on the lookout for problems and then use either a civil arm or criminal arm. It's not that kind of a regulator at all. It's a self-regulatory body that has delegation from the state through the state constitutions and so forth. But it's really the industry regulating itself, A, and B, being a passive regulator where if a client brings a complaint, then the bar will investigate. And there's issues, I mean...
Tell that to the New York City Bar Association.
Yeah, no, I think that there's a complex story to be told here about what kind of a regulator do we have here, to the extent that the only regulation that we have that's meaningful is the regulation of the lawyers and not the funders, and it's bar associations who are not, they're not regulators in the more mainstream sense. It's not the FTC, it's not the SEC. And so, among other things, we have very ineffective enforcement, right? So even if the rules of ethics and imposing obligations on lawyers are enough, which I don't think they are, and I think disclosure is somewhat of a red herring discussion because I think we should talk about much more important things like should there be fiduciary duties on funders, the way there are in lawyers and insurers, who are the other types of entities that are allowed funding. But part of that discussion is, okay, in the current world, it's only the bar associations that we're told, oh, we don't need any regulation, the lawyers are regulated. Who's regulating them? The bar association. So now we need to look at, is this effective regulation? Are we actually seeing actual enforcement? And I think that's, again, it's a whole issue, but thank you for the question.
Do we have any other questions? Okay, thank you all so much. It's very interesting.